Are you caught in the complex web of property disputes specifically relating to partition suits in India? If you have ever wondered how to navigate this challenging legal terrain, you are at the right place. Hi, my name is Damini and welcome to Vakilsearch's Real Estate Investment Series. In this episode, we will be discussing partition suits in India. Let's first get the basics right. What is partition and partition suit in India? Partition essentially means separation. Partition suit, on the other hand, represents a legal dispute between parties who own a common property but have different ideas about its use and entitlement. This legal process is a powerful tool for resolving conflicts over property interest. Through the partition suit, the court can decide the ownership rights of the members based on legal precedents. Let's get into detail on filing a partition suit. Who can file a partition suit in India? Any or all of the co-owners of a property can file a partition suit. The co-owners can be legal heirs too if it is a family property. Co-owners can be defined as those who have a joint title to the property either by inheritance, gift or purchase. Legal heirs are those who are entitled to inherit the property of a deceased person in accordance with the law of succession. Next, what is the cost for filing a partition suit? The cost for filing a partition suit may vary from state to state. For example, the cost for filing a partition suit in Karnataka is fixed at 200 rupees, whereas the same suit costs 500 in New Delhi. Also, the court fees can spike high in case if the claimant is not in possession of the property. Can a minor file a partition suit? Yes, minors can file a partition suit if they are supported or represented by their legal guardian or representative. The court may appoint a guardian to represent the minor in the suit. The court may direct that the property be partitioned in such a way that the minor's share is protected and preserved. Now, let's see the procedure to file a partition suit in India. Before filing any suit, it is compulsory to send a legal notice to the concerned party. Post that, the first step is drafting a plaint. The second step is paying the partition suit court fee, which may vary based on the case and the state in which it is filed. Once the payment is complete, the court will fix a date to take your dispute and adjudicate it. Now, what documents you should hold to file a partition suit in India? ID proof of legally identified heirs, certified copies of the property, valuation of the property, residence proof of the legal heirs, and the family tree. There are two decrees granted in a partition suit, preliminary decree and final decree. Preliminary decree will talk about the entitlement of shares to the parties to the suit, whereas the final decree will talk about the allotment of shares to the party to the suit. While the guidelines and procedure for a partition suit are relatively straightforward, it is strongly recommended to seek an amicable settlement wherever possible. This can be done through a partition deed. That brings us to a next important question. Is it compulsory to register a partition deed in India? As per Section 17 of the Indian Registrations Act of 1908, it is compulsory to register a partition deed in India. An unregistered partition deed is not valid and cannot be used as evidence in a court of law. Registering a partition deed helps to protect your rights in the property and avoid disputes in the future. Likewise, the preliminary decree and the final decree granted by the court in a partition suit should also be registered. If you require any legal assistance in dealing with a partition suit, please reach out to us at www.vakilsearch.com or call us at 7200-365-365. Follow Vakilsearch's YouTube channel for more exciting videos on real estate investment series. Stay tuned.